I really would like to get John up here. John's done a significant amount of work in this field, as much as with Compassion Club growers and clubs like mine and working in the field. He's also one of the lead attorneys in the Insight decision or challenge here in Vancouver, which is very important as well. We're so pleased to have him here, and I'm so happy to have him working on my court case. I've seen him working for a long time, and this is the first time we've worked directly together, really. So thank you so much, Jim.
Thank you. Thank you very much. Excuse me, I've been fighting a bit of a cold, so I'm coughing from time to time. I thought I'd start, in fact, this keeps sliding off here, so I think what I'll do is I'll just put it here. But the last point about black markets and the prices, and I think the best argument for why prohibition doesn't work is to focus not just on the drug or a particular thing, but a legal approach. You know, the other legal approaches are to regulate and tax, and that's usually what we mean by legalization. But to illustrate the folly of prohibition, my practice involves not just representing people who are charged with offenses, but I'm also in Abbotsford, so I'm surrounded by prisons, the Kingston of the West. And so I deal with a lot of people who are in prison. And what they, in their wisdom, decided to do a couple of years ago was to ban tobacco.
Oh, smart.
Well, you know, we've been very successful in educating people to reduce their tobacco consumption because of the harms that it can cause to you. We've never used prohibition in relation to tobacco that I can think of or from my studies. So what happened when they banned tobacco in the prisons? The price of a cigarette went from $1 to $10. People are now going to the hole for being involved in the tobacco trade. People are being shipped to maximum security for trafficking in tobacco. The staff, of course, used to come in the morning to their shift and leave in the afternoon. Now go in and out 20 times a day because they have to go out to the parking lot to smoke. This also gives them the opportunity to bring in tobacco 20 times a day instead of once a day, because after all, they're addicted too, and they have some sympathy for the prisoner addicts who can't get the same drug that they're into. And so it's just a matter of time. In fact, I'm told people are already been stabbed over tobacco. When the price goes up and you've only got a little money, it becomes of great value. That's what happens. You know, that's the problem with the entire drug war. I had a person call me the other day who said, listen, some people came in and they beat me up and they're threatening to beat up my family and they're saying I owe them money. What can you do? I have to say, there's nothing I can do. You're involved in an unlawful activity. You can't come to see a lawyer. You can't sue the people or go get a restraining order or anything like that. You chose to get involved in an underground black market activity, and so you can defend yourself or you can go to the police. Of course, if you go to the police and if they find out you went to the police, then they're going to brand you as a rat, and that might make your family in greater danger. So the whole thing is completely insane. It doesn't make any sense whatsoever. And I say that tobacco illustration just is the classic example of that type of an approach. So it's not the particular drug necessarily, it's the approach, because that approach, if there's a demand, forces the price up, and that's what you get. Anyway, I thought I'd also tell you, first of all, I'm also a member of LEAP. I'm pleased to wear my pin. Jack Cole, who was the founding member, invited me to become a member. And I encourage all of you to do so. I get great reactions in the halls of the courthouses, especially from police officers who come up to me and they say, "Is that a police badge you're wearing, Conroy?" Which usually, when they look closer and see that it's leaked, they all jump back, having heard about it. But as I think some of the speakers said, many of them are actually supportive, but they won't say so until they retire or have left the force. So, I thought I'd tell you another funny story before trying to get you into the framework of what's been going on and up to where we currently are, particularly with the Van Du case. One of my favorite cases was I acted once for Watermelon. You all know who Watermelon is?
Yeah.
Okay. So Watermelon was sunbathing out at Wreck Beach, which all of you know is a nude beach. And she became quite well known as the lady who sold crazy cookies. And so Watermelon would walk up and down Wreck Beach advertising crazy cookies. And so the UBC detachment decided to do, yes, an undercover operation on a nude beach. So they put their bathing suits on, went down to Wreck Beach, and as Watermelon came by, they said, "Oh, you know, we'd like to try some," and they had her explain what was in them and all these sorts of things so as to incriminate herself. And then the first time they actually busted her right there on the beach. There was almost a riot because of all the supporters of Watermelon. I mean, and the irony was some other people were selling booze and other things, and that wasn't the problem. It was the cookies that they were after. So they did it, I think, about 3 times, but wisened up and didn't bust her the subsequent times until she was up the stairs there at the top of the beach. And so the interesting thing was they charged her with trafficking in cannabis marijuana. Now, in Canada, you have cannabis marijuana. These are the definitions in the Controlled Drugs and Substances Act, and you have cannabis resin. And it turned out, I went home and I said to my wife, "You know, they charged you with cookies. You know, how are they able to tell what's in the cookie? What do they do?" And she said, "Well, they wouldn't be able to tell when you make up the batter and so on. They're not going to be able to tell as long as you've ground everything up properly and so on." So when we got to cross-examine the expert, he conceded that what they had done was they had looked at the cookie under a microscope and they didn't see any green plant-like material. So they said, "Well, it's not cannabis marijuana, it's cannabis resin." And they charged her with trafficking in cannabis resin. Well, cross-examination proceeded. "You didn't see any resin in that cookie, did you?" "Oh, didn't." So the funny part of it was that the judge then acquitted her because they couldn't prove that she had trafficked in cannabis resin. And from then on, they charge people with the specific cannabinoid in the cookie. So they will do a chemical analysis now to try and find THC or CBD.
And at first
And it was
they charged
THC.
me with cannabis resin, but then a combination of John's cases with watermelons and one of my other ones at the club where we were charged with cannabis resin and beat it, they changed it to trafficking in THC. And we had Dr. David Pate come testify, who worked with John in Watermelon's case as well. And the reason I was convicted was because I had professed to be having a pot cookie giveaway, and I tried to argue that there was so little pot in it, it was essentially a hemp cookie because it was low grade, but they didn't buy that. A trace amount of THC is enough for a conviction, unfortunately. No, sharing is trafficking, yeah. I get convicted twice of trafficking.
The whole plant is illegal in Canada, except, what do they call them? I forget the term for the seeds that are not sterile or not fertile, I should say.
I think this non-viable hemp.
Non-viable, that's the term they use. So everything except non-viable seeds is illegal in Canada, the whole plant. Anyway, the part that I wanted to talk to you about is essentially the law situation in Canada, which I'm assuming is what you really want to hear. I acted for Randy Kane, who was charged with David Malmo Levine. Well, not charged with, they went up the ladder together to the courts. David, as you probably know, had a harm reduction club going on in Vancouver. Randy Kane was simply sitting at the beach at White Rock, and the police came up to his, where they were sitting, him and a friend, and found a tiny little roach on Randy. And then everybody paid attention who was at the beach, and they charged him with simple possession. And he came to me, this was I think back in somewhere in the 80s, and we decided we'd do a challenge. And it went on for quite a few years, first through BC Provincial Court, because that's where you usually start when it's a simple possession. Malmo, on the other hand, took a preliminary hearing and went up to Supreme Court, and so we had to race to try and catch up to him. His decision in Supreme Court came down unfavorably and affected our provincial court case, but we appealed, got through Supreme Court, and we were all together in the Court of Appeal, thank goodness. And then we were all together in the Supreme Court of Canada. David had his hemp tie and his hemp suit representing himself, and it was quite an interesting event. And we were saying, and as I'm assuming all of you know, in 1982, Canada became a constitutional democracy. Prior to that, we were a parliamentary democracy. Parliament was supreme. We had a Bill of Rights, but it was subject to whatever Parliament did. But in 1982, we got the Canadian Charter of Rights and Freedoms as a constitutional document. So that is the supreme law of the land. All the politicians, everybody is subject to the Charter. And the Charter, in some of its provisions, provides that you all, everyone, not just citizens, everyone has the right to life, liberty, and the security of their person, and the right not to be deprived of those rights, except in accordance with something called the principles of fundamental justice. So we said, well, when you threaten somebody with a criminal offense, you're threatening their liberty. Courts agreed. When you chase after people and cause them stress, high levels of stress, Morgenthaler was mentioned earlier. Out of the Morgenthaler case, the courts decided that state-induced psychological stress is affecting the security of your person. So we argued that as well. So liberty and the security of the person were impacted by the creation of the offense of possession of marijuana. So what was the principle of fundamental justice that was in issue? We said it was the John Stuart Mill harm principle. We said if you are engaged in conduct that doesn't pose a risk of significant harm to others, then that's the principle. And the state should not be allowed to criminalize and threaten your liberty or the security of your person if your conduct does not involve that significant risk of harm to others. So that was the deprivation in terms of principles of fundamental justice. Ultimately, the Supreme Court of Canada said, no, you're wrong. That's not a principle of fundamental justice. The principles of fundamental justice in issue are arbitrariness, overbreadth, going too far, and something called gross disproportionality in effects. And it's that last one that they particularly focused on. So if the government, even though it's acting within its criminal law power, and in Canada the criminal law power is a federal power, if in enforcing that law it causes gross disproportionate effects, then they're acting in an unconstitutional manner. And they said, marijuana smokers, they're engaged in civil disobedience. They're not addicted. They bring the consequences of the criminal justice system onto themselves. So when we do this weighing of what's proportionate or disproportionate, and we're saying, look, the marijuana smoker gets a criminal record, impacts in terms of their jobs, all those sorts of things. They said, well, when we weigh these things, you know, they bring those consequences onto themselves. We have to have a criminal justice system. They're not addicted. And so that was the key part of that decision, or that I took from that decision. I mean, they were actually quite good in a way, the court. They were saying, look, Parliament can change this, and, you know, they weren't suggesting that this was a particularly good thing necessarily for Parliament to do, but that was for Parliament. It's, as somebody said a moment ago, it's a policy question, it's a political question. We can only try and find these legal arguments here and there to try and constrain them or try and succeed, but generally it's a political question. So that then brought me into, came to my attention anyway, was the safe injection site battle. I've been involved also with Pivot Legal Society, and so I was asked to take that case on, and of course there the people are addicted. They're not engaged in civil disobedience. Addiction is a recognized illness or disease. It involves craving to get that particular drug. That's part of the illness. When we were in front of the Supreme Court of BC on this case, all parties, even the federal government's counsel, agreed with that definition of addiction, and that addiction is an illness. And so the situation we have in terms of that case is the same structure as the Malmo-Levine case involving Section 7 of the Charter. Life is also involved, because the whole basis for the safe injection site came as a result of the province of British Columbia through Vancouver Coastal Health and the Portland Hotel Society, creation of VANDU, the Vancouver Area Network of Drug Users, and as a harm reduction effort to try and reach this hard-to-reach group who won't come near government. We have to encourage them to come, and who many of them were dying. We had a huge increase in overdose deaths in Vancouver over a period. So it was a government-identified situation. So the addict, when the dealer shows up and they get their drug, heroin, cocaine, crack cocaine, heroin's actually down. It's more crack and cocaine these days. The addict will often go into the dark alley waiting for the dealer to show up. The dealer shows up. They all come out of their nooks and crannies, get the drug, all shoot up, miss their veins, get abscesses, share the needles, and then go off and have sex with somebody else and spread hepatitis C, hepatitis A, HIV, AIDS, these sorts of things. It's a public health crisis going on. So what was it that drives the person to go into the attic or into the alley? It's looking over their shoulders, worrying about law enforcement. Why do they shoot up quickly? Worrying about law enforcement. Share the drugs, share the needle. Worrying about law enforcement. So it's not the drug that causes these unsafe practices in unsafe places. It's the law. It's the actual enforcement of the law. And the Vancouver police recognize this. The Vancouver police support Insight. They don't bust people going into Insight with their drugs to find a safe place to inject so that they can inject in the presence of a nurse who will see whether they're going to overdose or not, and who will be able to then gently encourage them to go into the chill-out room afterwards to be exposed to what little treatment options exist. And if they really want to get into detox, go straight upstairs, get right into the detox facility. So the addict is not choosing to bring these consequences onto themselves the way they say that the pot smoker is, the marijuana smoker. The addict is driven to do this by their addiction. So we're able to successfully argue in BC Supreme Court and in the Court of Appeal that the prohibition against the possession of these, what we call Schedule I drugs, does result, the enforcement of that law does result in grossly disproportionate effects. As I say, the Vancouver police have an overdose policy. If they hear there's been an overdose or there's some health issue, they will not go to the scene of that unless the emergency health personnel ask them to. Why? Because they know that if the addict sees a policeman or knows that a policeman's coming, they're far more likely to do all the drugs as quickly as possible and overdose. And so to prevent overdose deaths, the Vancouver police created this policy. So we have the frontline people, the addict and the police officer, seeing what the problem is and recognizing that to enforce the law as it currently exists does make things worse. It has the exact opposite effect to preventing harm. It causes harm. And that's the argument that the courts have accepted. Now, down in Supreme Court, the judge found that the principle was arbitrariness. Parliament had created this law without differentiating between the different types of drugs and the different types of effects and so on that they might have. In the Court of Appeal, I should say at trial, the judge accepted overbreadth and gross disproportionality as well. In the Court of Appeal, they did a funny thing. They sort of focused solely on overbreadth and limited the decision to the geographical confines of Insight itself, when the gross disproportionate effects are happening outside of Insight, and Insight is designed to ameliorate those conditions and problems. So the government appeal, Portland Hotel Society opposed the appeal. We, on behalf of Vandu, actually supported it because we wanted to make sure that this issue is decided by the Supreme Court of Canada. We were quite convinced they were going to grant leave anyway. They granted leave. They granted us leave on a cross appeal to make sure that the whole Section 7 issue is before the court. It's not limited to the confines of Insight. And so on May 12th of this year, we'll be in the Supreme Court of Canada making this argument, and my hope and expectation is that the Supreme Court of Canada will, following Malmo, Levine, and Kane, accept that the enforcement of this law in relation to addicted persons results in grossly disproportionate effects, the opposite to what the law is intended, and will strike it down. Now, they're not going to strike down the law in the sense of all hard drugs are now legal or anything like that. The expectation I have is that they will carve out an exception for addicts. Now, the federal government's lawyers just can't grasp that for a moment. They say these are the people who use the drugs the most that are really causing this market. How can you exempt them? Well, they're the ones who are sick. They're the ones who have an illness. They're the ones who are having the grossly disproportionate effects. And so if they carve out an exemption for addicts, just like they've carved out an exemption for medical marijuana, the addict will be able to possess, from whatever source they obtain it from. If the government had any brains, they'd come up with a supply, but that's asking them way too much. So the addict will have a piece of paper and will be able to go and get treatment from their doctor through the safe injection site or whatever, and not have to worry anymore about going into the alley and resorting to the unsafe practices and so on. So that's what we hope to achieve in that case. And then we'll get all that right-wing stuff about how addictive marijuana is, and we'll go back to the Supreme Court of Canada and say marijuana is addictive after all, too. So that's the framework of the analysis in terms of these cases that have been going on. I also do a lot of international treaty transfer cases, and I know this is of interest to you because of what's happened to Mark Emery. I have acted for Mark from time to time. I believe my associate Kirk Tusaw is currently handling his situation. You know he's in the United States. He's serving his sentence there. I acted for Michelle Rainey in that case, and as you know, it was interesting because the U.S. attorneys actually got quite sympathetic, first because of her Crohn's, but particularly when she got cancer. And the U.S. attorney we were dealing with agreed that Michelle and Greg could serve their sentences here in Canada by way of probation. And that helped Mark because that brought them down also in relation to the penalty that they were looking for in terms of his situation. And unfortunately, though, there was hundreds of issues that came up, but ultimately the decision was made, and he pled and returned, went to the U.S., and is now serving his sentence. Now, it used to be that the U.S. was the problem in terms of these treaty transfers, in terms of getting people back. Canada would approve them, invariably. Now, you have to be a Canadian citizen to be eligible, and the important charter right that we say applies here is Section 6 of the Charter, which says that every citizen has the right to enter, remain in, and leave Canada. And so, if you're a citizen, you have that right to enter. Now, obviously, you can't exercise that right to enter if the country in which you're incarcerated won't let you go. But once the country says, yes, you can go, we say, well, then Section 6 is engaged. I succeeded in that argument in a case where they had, actually Canada, under the previous Conservative government, had basically screwed a guy around for about 9¼ years. And the court found 9¼ years of willful bad faith by the federal government towards one of its citizens, and we're now suing them for damages. Unfortunately, subsequent to that, there's been a couple of cases where the courts have said that Section 6 doesn't apply. That issue is now in the Federal Court of Appeal in a case called DeVito, and I had about 10 cases filed to overturn the minister's decision denying citizens. It started with Stockwell Day, and then Peter Van Loan, and now we have a man called Vic Taves as the minister. And they regularly deny drug offenders. And so I've gone to court quite a bit and had those decisions quashed and then got them back. We had 10 outstanding. We won a case. They said, okay, we'll reconsider those 10. They approved 5 and denied 5. We argued those 5 about 3-4 months ago. We still don't have a decision. So the situation on the transfers is we're waiting for those decisions. We've got about 10 other cases filed at the moment. When Mark gets U.S. approval, we'll then see what the federal government does. If they approve him, great. He'll come probably out to Matsqui, Abbotsford, where I am, to start off with. But if they deny him, then the procedure will be to go to the federal court to seek to quash the decision of the minister denying him. My hope, though, is that when these other cases come down that we're waiting for, that that will constrain the minister further and may make some changes in terms of just what leeway they have. Our objective, of course, is to establish that a Canadian citizen has a right to return to Canada when the country in which he is located says he can go. And we say that that's the true ambit of Section 6 of the Charter. Again, I expect this will go all the way to the Supreme Court of Canada before it's settled. So that's where things sit in terms of Mark at the moment. He's really in the early stages of the situation, and it's going to take some time before we'll know what the situation is. So those are some of the basic things I wanted to talk to you about in terms of the law. I did become involved for Normal Canada. I actually incorporated Normal Canada back in about 1977, I think it was. And so we do have a Canada Corporation incorporated with the various objectives. Keith Strope, who's still involved with Normal in the U.S., used to come up here to Vancouver. He usually got busted at the border, and we'd have to bail him out in order that he'd get to make his speech before they'd kick him back out of the country. But so in that period, in the early 70s, really it was, late 60s, early 70s, that organization did exist here in Canada, and we had chapters all over the place, and it was quite an exciting time. Of course, in those days, people were still going to jail for even possession of marijuana. And so people were more fired up and so on about it. Over the years, it sort of died down. There was a period of time where it was quite active again, mid-'80s, I think it was, and then again through lack of funding and lack of people getting involved, it sort of died down. There's, in Canada, always been, I think, a bit of a question about whether we should also be Normal, because Normal is the U.S. and there's various other groups that have grown up, or some that have not liked Normal because they didn't think Normal did very much for them and so on. My view is that it's simply the brand that everybody knows is Normal. And so it's really a business of getting everybody together, trying to minimize the petty politics and to look at the big picture and say we need an organization across the country and importantly well connected to the U.S. organization, because what happens there impacts here and what happens here impacts there. And we need to, I think, work as closely together as possible in order to achieve it. But to change the laws in relation to cannabis in Canada is primarily a political situation. And it's expensive, it's difficult to run a membership-based organization across the country with chapters in every little town and city, constantly lobbying their MPs, their local council, that sort of thing. But that's, I'm afraid, what I think you'll have to do in order to change the law. You're not going to be able to do it just online, chatting, having polls. these sorts of things. You're going to have to really work hard to create a strong grassroots organization to keep on the backs of the politicians and to show them just how stupid, really, really stupid the current approach is. I mean, I tell them how I make money every time they prohibit something. We lawyers, criminal defense lawyers anyway, make money. And we keep pointing out these things to them. We insult them. We tell them how stupid they are, and they keep rewarding us by passing more laws, you know? I mean, how do you get the message through? Mandatory minimums. I got to appear in front of the Senate on that bill last fall, I think it was. And in my research, I was able to find that the current Minister of Justice, Mr. Nicholson, when he was on one of the earlier, back in the 80s, we had the Sentencing Commission, then we had the government's response to the Sentencing Commission, and all these royal commissions and things all dealing with sentencing and these issues. And all of the evidence there pointed out that mandatory minimums do not work. They make things worse. They catch the marginal person, ends up with a mandatory minimum sentence. It's ridiculous. And Nicholson was on the committee that supported that finding that mandatory minimums don't work, and yet there he is as the lead guy running this bill. And so, you know, this group that's in power, we now say that Ottawa has become a no-fact zone. You know, it used to be that policy was driven by investigations, royal commissions looking into the issue to try and come up with what was the right thing. That's not what happens. They have undone every positive thing pretty well that happened during that whole period of the 80s and into the 90s that was based on evidence. They've undone without any evidence. And one of the most notable places is in the prisons. Our prisons have really gone backwards from where they were. The last 5 years has really been quite ridiculous in terms of what's happened, in terms of lack of programming and these sorts of things. So,
can you make a quick comment on Revenue Canada and Compassion Club growers?
Oh, right. As a result of one fellow getting busted, the Canada Revenue Agency said to themselves, there must be quite a few people like this who are going for compassion clubs and who aren't declaring their income. And many, of course, thought that if you're doing something unlawful, which is what they're doing, that you can't tell any branch of the government this because they'll bust you. But the fact is, under the Income Tax Act, their first concern is that you declare your income and pay your taxes, and there's a section of the Act which forbids them from telling the police, especially if you come to them under what's called the Voluntary Disclosure Program. If they get the information through a requisition or through a police investigation, then you're stuck and you're going to end up with all kinds of back taxes and penalties and so on and so forth, and they can go back quite a long way. So the requisition was served on the BC Compassion Club Society, which I think, along with Ted's group, are probably the two longest groups going, something like that. And the concern was that 2 of the growers out of about 35 had insisted on getting checks. And so once they got all of the documents that the club had, which they were going to have the power under the law to go and seize if they weren't produced, they were going to fine these 2. So we went to court just to challenge the requisition on technical grounds, and they agreed to set it aside, and then we've been encouraging all the BC Compassion Club growers to go in through this voluntary disclosure program. We have a tax lawyer and an accountant, and so the gross income is easy enough to calculate because there's all the purchase orders from the Compassion Club. But they've figured out a template now in terms of expenses, because your taxable income is what has to be declared, not your gross income. You pay your tax on the net income. So you figure out what all your expenses are, figure out what your income has been over those few years, and get in on the voluntary disclosure program. They sometimes only go back 3 years, and they have the power to waive penalties and interest and all sorts of things. And they're interested because they're hoping, of course, that all sorts of growers, especially medicinal growers, will now come in and be fully legal in the sense that they're also paying their taxes. I've often said to people who are just in the commercial market that if you can, you should pay your taxes, because if I have to stand up on your behalf at a sentencing, and if I'm able to say to the court, and this person paid their taxes, Judge, here's the evidence, that's going to stand you in very good stead in front of that court, because a big part of it is they think everybody's getting away with black money and not paying taxes. There's another thing to think about. So I think that sort of covers most of the areas. How are we doing for time? Okay, so if anybody has questions about any of the various issues, I'd be happy to try and answer.
Well, actually, to tell you the truth here, folks, time is just so precious. John hopefully can stay for a few minutes here, even though the mic is going to shut down at 4. We're going to be in the room here for a few more minutes. I know we've let other speakers have questions, but I'm sorry, John, time is just going by so quickly, and I really want to get Dana up here as well. But just a couple